afternoon, everyone, and welcome to today's board education and training session, Navigating the Waters of Transitional Control, Avoiding the Perils and Pitfalls. We are so happy for you to join us today for this presentation. Today we will have two presenters. Our first presenter is attorney Richard Wagner, who's a senior associate here at this firm. For this presentation, he is one of the captains of our pirate ship. He has over 45 years of experience in this area and will provide you with a plethora of information. And new to our presentations, we are introducing one of our associates, our newest associate, Ms. Jessamyne Kalabat. She has been with our firm since January and brings her specialization in real estate, probate, and business law matters to our firm. So again, we're happy that you joined us today. I am going to turn it over to Jasmine to start the presentation. If you have any questions, you can feel free to put them in the chat and I will ask them throughout the presentation as appropriate. And we will also have a question and answer section at the end. Again, thanks for joining us, and I will let Jessamyne have the stage.
Thank you, Melissa. My name is Jessamyne Kalabat, as Melissa said, and I'll first be talking about the transitional control. Now, the transitional period is the turnover between the creating developer to the first board for the association for either condominium or homeowner association. This occurs in different dates during homeowner and condominium association. The traditional date for condominium associations is controlled by Michigan State Law, MCL 559110. And in there, it explains that typically, once you have 1/3 of non-developer co-owners that have bought units, that is when, within 120 days of that period, is when there should be an advisory board that is created to start the transition between the developer and the board members. This, if we do not get 1/3 within a year, then the initial conveyance, then an advisory board will be established after 1 year. Once the majority of board members are elected by non-developer owners, the advisory board is discontinued.
Okay, then we roll over to the HOAs, or are you going to keep on going to the statute, Chris?
I'm waiting for the slide to change.
Okay.
So continuing on, once you have 25% of units that have been that can be created and they're conveyed to non-developer co-owners, then you should have at least one director elected, official director elected to the board of the association, board of directors. Once you have 50% of units, you should have at least 1/3 of the board directors that is created in the bylaw time and board directors. 1/3 of that number should be elected. And once you have 75%, but no more than 90%, then you should have all of the board members elected. And then also controlling that matter is if you don't get, if the condominium project was not completed all at once, the board, it's a little different. It's within 54 months of the first conveyance of title to a non-developer co-owner. And if there's not less than 75% of the units that may be created, that are created and ready to be conveyed to co-owners, then the owners have the right to elect, per the condo documents, a number of board members equal to the percentage of the units they hold. The developer has the right to elect, according to the condominium documents, a number of board members also equal to the percentage of units which are owned by the developer and for which all assessments are payable by the developer. When it comes to funding, the MCL 559.511, it controls the law And the standard of funding is required that all condominium board members for the association have shall equal 10% of the association's current annual budget in a reserve fund. And those reserve funds are to be used for major repairs and replacements of the common elements that the association is responsible for. So before transitioning happening, the developer must have that funds established per the condominium documents of what the funding is by doing a study at the time the developer does that. Okay. Richard,
Okay,
about homeowners?
yeah, I'm going to talk about today. Thank you for everyone joining us. We're glad to have you every time. These seminars are really important. This may not seem important because it's talking about transitional control, but the information that we're going to impart today deals with not only protections regarding transitional control, but it's information that you need to acquire if you're a board member for purposes of the proper administration of your community. These are all things that should be on your mind to investigate and make sure that you have these materials. If you're not on the board or you're property management or you're a member of the association, the property manager wants to make sure that they assist the board in obtaining this information. And the member wants to make sure that their board is getting this information so that the community can be properly administered. Unfortunately, there is no parallel statutory scheme for purposes of homeowners associations. It has been proposed a number of times in terms of trying to enact the legislation to have mandated requirements for developers, or basically what's referred to as declarants, who create subdivision associations. Many other states, a lot of the southern states, Florida and that, do have a statutory scheme for both the condos and for an HOA. Michigan does not have that yet, although they keep working on that. So, and the difference what we're looking at is typically, rather than the term developer, which has a specific definition in the Condominium Act, in terms of what a developer or successor developer is and what the responsibilities are, in the homeowners association, you're usually dealing with what's called a declarant. And the declarant is the person who basically takes the parcel of land. He may be the proprietor of the plat, or he may, someone else may dedicate the land and he takes over to decide how and what's going to be done with the property, and sets forth the governing documents such as the declaration and the bylaws. We're going to talk about that a little later on, but basically we wanted you to understand that unfortunately for homeowners, there is not a statutory scheme, but that does not diminish the importance in terms of getting the information and making the declarant responsible for whatever it is he's turning over to the homeowners to administer as their community. So with that, we'll go back to Jessamyne with reference to what's the developer's responsibility. I believe, are we on that page?
For condominium associations, when there is a board fully elected, which is when there's 75% of non-developer owners that own a unit, but no more than 90, at that point you should have a full board, and that number is determined by the condominium documents. But at that time, there's a number of responsibilities that the developer has to this new board now that the advisory board is dissolved. First of all, they have to provide, according to the rules, that they have to provide a disclosure statement. What's in that disclosure statement is a number of things, but first it has to be clear and readable. It's, for laymen, it cannot be a complicated text for disclosure. They have to put in a clear and concise way with a table of contents to make it easier for the board members to determine all the documents are in there and understand what they are. The documents that they must apply are the condominium project warranties, the size and scope of the condominium project budget and assessment, the condominium project recreational facilities, the condominium project restrictions, the developer's background and experience, legal proceedings involving the condominium project or developer, which includes even with working with the city to get any variances or whatever. Then also the condominium association management contracts that they've already created, hired a property management and any other vendors that are used to help manage and take care of the condominium association. And then any other information and materials that would will inform purchasers about the unique characteristics of the condominium project. That includes the bylaws that explain any rules and restrictions. If this is a non-pet friendly condominium project and a potential purchaser has multiple animals, they would like to know that before buying that condominium in that unit to determine whether this characteristics of this particular project and community is the right fit for them. Now, with that, it all has to be organized. They also have to provide the articles of incorporations, any documents that are provided for Lara that have been filed. So any continuation of the corporation for Lara, any assumed names that have been filed with Lara, any tax returns, any banking information, finances, budgets, all these stuff have to be turned over to the board. Richard, do you want to talk about what they have to provide for the homeowner association?
Yeah, should be pointed out that the homeowners association, the subdivision, it does not have a disclosure booklet requirement. Like we said, there's no statutory scheme, but frequently you're going to see a little bound document that's kind of like a welcome to your community. It's going to contain a copy of the declaration and the bylaws, and it could have possibly two different sets of bylaws, one for the bylaws for the operation of the community in terms of filling in the details on any restrictions that are in the declaration, and a set of bylaws for the operation of the corporation, because the association, just like the condo association, is governed by the Michigan Nonprofit Corporation Act, which is MCL 450.2101 FC. And as a consequence, the homeowner subdivision is going to be governed by the same statutory procedures as a condominium with reference to how the affairs are administered. In these welcome to the community type booklets, it's going to probably tell you, aside from the documents, it'll probably have the budget for purposes of the typically AMC, the annual maintenance charges for the homeowners association, or they could be, they just call them assessments. Whatever you do, don't call them dues, because they're not dues. You're not a club, neither the condo or the homeowners association. We're constantly correcting board members, like, oh, it's not dues, it's assessments. You are a corporation. You're going to want to get those documents, and you're going to want to get the same materials like Jessamyne just mentioned. Certainly you want to know if there are plans for recreational amenities, when it's going to be done. You want to know, is he going to do sub number 1, sub number 2, sub number 3? Is the association that he forms going to be the controlling corporate entity for all 3 or 4 associations? Is there agreements with adjacent pieces of property with reference that they have shared amenities or shared easements or shared utilities? You certainly want to ask about the developer or the declarant's background. You want to get as much information as possible. You know, has he built other subdivisions? Has there been complaints in other subdivisions? Or he's had some problems, but he took care of those problems. And that's the kind of things that's important to you as a board for purposes of administering the affairs of your community. You want to know that whether there's been legal proceedings involving this particular declarant. Now, the declarant could be the person that just creates the subdivision and then has builders that buy different lots from them and builds homes. So then it's going to be between the homeowner and the builder any problem that they have with reference to the actual construction of the home. The declarant, for purposes of the subdivision, is basically going to be responsible for the common areas, anything that's owned in common that either has been dedicated as part of the plat or has been by deed transferred to the association. For example, the clubhouse or pools or whatever other amenities. Some associations have an actual deed, and in which case there's a taxing responsibility if they have a deed to the property, rather than it just being with reference to areas that are dedicated to the common benefit of everyone, right? And you got to remember too that you're always dealing with an entity. This person could have ABC Corporation for this subdivision and EFG Corporation for another subdivision. And you want to know what it's been happening. Has he got a good reputation? He or she, I should say, have a good reputation in terms of what they've developed. And you want to make sure that you get the documents and get the obligations on all contracts, management agreements. Management agreements are really important in subdivisions, probably more so in subdivisions than they are condominiums, because frequently what happens is you may get a runaround back and forth. They will hire a property manager and who's basically going to collect the annual maintenance fee and pay the expenses and make sure that the MARs are filed for Lansing and that. But they're not really going to take care of the common areas or anything else. So then you get the phone calls of the developer, they say, call the managing agent, and the management agreement says, well, all we're supposed to do is just collect money. So you kind of go back and forth. So it's really important to find out what responsibilities and what authority does the property manager have for addressing your concerns in the community. You also want to know about any agreements or requirements in municipalities, if there's conservation agreements or landscaping and entrances or greenbelt areas for either the local municipality or for the state of Michigan by way of a conservation easement. These are all important things to make sure that you have, because sooner or later, if it's not in your declaration, typically with municipalities, they will have an article pertaining to certain green areas or detention ponds, retention ponds, conservation areas, that you're ultimately, when you assume control of this community, are going to be responsible to fulfill those obligations. And typically they have language that if you don't do it, the municipality or the state has the authority to come in and do it and charge it back to the community. So it's very important for you to get these documents that we've been talking about. All right. So
And continuing on with maintenance documents, condo associations, things that you do want to get that aren't always included, but it is the best practice to obtain as much information, especially these items, is the list of as-built drawings of all the building and facility and irrigation water systems that the association has to map, set of the track maps, the complete landscaping drawings and specifications showing all the plants and lawns, because that is especially during within the common elements that the association is responsible to maintain and take care of, and the association or the property manager, depending on the contract with the property manager. You want an inventory of all the association's property in the common elements. You also want any warranties for equipment. This is specifically important when you have a pool within the association, and equipment warranties for all the items that you need to be using that are used to take care of the pool and make sure that it stays clean and safe for state and local ordinances and requirements. You want a list of the list of manufacturers of paints of the roof and roofing materials. This is quite important when back in the 60s and 70s when lead paint was quite common and could become a potential issue. Now that is an issue, but you still want to get that information. You want the construction subcontractors and the principals related to those subcontractors that are used. You also, if the developer is not the general contractor, you do want that general contractor's information as well, because you want to obtain to know who's responsible for what defect and when. There is always a number of issues where for a road you have a subcontractor, subcontractor, but they have a contractor, developer, and the general contractor that they're indemnified for any defects in there within the warranty. If you sue the road, then it's not going to be, they're not responsible to fix any of that. And vice versa, whether the developer and the general contractor has indemnification clauses with their subcontractors. You want to determine that, know that, so you know who to go after should there be an issue with any of that, whether it's the road, whether it's roofing, whether it's windows, whatever, whether it's plumbing, whatever it may be, you need to have that information. He also wants the list for any vendors. So if you already have a lawn care company, if you have a tree trimming company that's already established, the insurance agents who within the insurance policy, who is the insurance agent, who's the policy with. You want to have all that information transferred over to you so they know that you're the one that is now the board member and the property manager are the ones in charge. And they are the ones that have the authority. We also want to know who that is and review that information to determine whether you want to continue with that. Richard, how is it different from homeowner association?
Okay, what's important to remember is this is always kind of like a wish list, unless it's specifically provided or mandated in the statute, in which we already know there isn't one for subdivisions. It's you're dealing, hopefully dealing in good faith. Not all developers or declarants are bad people, and they may have omitted something somewhere. So that's why it's important for you that when you assume control of the association, that you obtain all this information so that when you're called upon to address it, you're not just kind of like sitting there like, deer in the headlights trying to figure out what's going on. There's a number of things that declarants will typically do that you need to know about. For example, other things like lease agreements or land contracts or sales agreements with builders on different lots. You want to be aware of what's happening so that when you get that phone call from the homeowner or the email going, hey, we're supposed to have a whatever, so you want to basically know, all right, what role did any of these people have in dealing with common areas or common development? If it's purely a matter of the building structure that's solely in the responsibility, that's between the assigned builder or the contracted for builder and the homeowner. But you basically want to be aware of it. You don't want to have it pop up all of a sudden when they appear at the monthly meeting going, hey, what's going on over here? Something else that's really important, like I said before, management is really important in subdivisions, is you want to know what kind of enforcement action or architectural requests have been made, because it sets a pattern or establishes possibly waivers in terms of what the restrictions. In other words, they've got a restriction in the declaration, they got something in the bylaws. You can't have sheds, you can't have pools, above ground pools, you can't have this, you can't have that. Well, then you find out that the declarant, if he's the builder or whatever, has ended up entered into an agreement with a purchaser that says, okay, we're going to give you a nice pool, we're going to give you a nice shed so that you can have your riding lawnmower in it and everything else. And it's like, well, wait a minute. Now you put us into a situation where you're contrary to documents. So if you get control, or before you get control, if you can find out from the managing agent what kind of complaints have been filed, what kind of requests for alterations or modifications have been made, if it's addressed in the recorded documents. And don't forget, a lot of times bylaws, especially in subdivisions, are not recorded. And in contrast to condominiums, where the bylaws are Exhibit 8 attached to the master deed. And the same goes true with reference in terms of bylaws for the corporation. In the old days, condos had two sets of bylaws, one that was recorded as to the community subdivision, and a non-recorded set of bylaws for purpose of the operation of corporation. You could have the same thing. I have some homeowners association that have two different sets of bylaws, and neither one of them are recorded. So that's something we're going to talk about in terms of what to do amending documents. But you want to know whether or not the declarant has created a pattern of waiver of requirements, such as that you're going to end up having to deal with this in terms of, well, the documents say one thing, but this is what the declarant put in for me or allowed me to do. So you also want to know, and something I forgot to mention is that Jazz mentioned in terms of the as-bills. I can't tell you how many times that there's some kind of a master control, a master shut-off system for whatever, irrigation or utilities or some pump systems or pumping station systems. And the boards take over, they have no clue that they have a responsibility or nor even where to access this stuff. So they're getting taken advantage of perhaps by vendors because they know the intricate details of construction in the community and you don't know. it is important to get your hands on as many documents in terms of what was actually constructed and where items are located that you can deal with any problems. So in that regard, subdivisions takes a little more legwork than you might typically see with a condo, because a lot of times the condos, they do have a property management company that has very specific responsibilities, and they kind of pair up the documents or the requirements in the statute. When you don't have a statutory scheme, you're kind of operating in the Wild West. And that's why we make these recommendations for you to try to get them, certainly ask. And if you don't, well, then you don't, but you're going to have to deal with them. Sooner or later, you have to deal with one of these issues down the road.
Thing that you would like to get from the developers with condominium associations are some assurances, statements that the street traffic safety regulation signs are all installed in conformance with the state and local ordinances and association documents. Confirmation that fire hydrants were placed under the local government rules and maintenance plan. And also with that comes, it's especially important when you're looking at traffic safety, whether if a fire truck cannot get in, if there's cars parked on one side or both sides of the street, then a lot of times you would put that in the rules and regulations that no parking in the street due to traffic safety control or fire safety control. You also want confirmation from the city or the county that the emergency centers have been mapped out, mapped in the association for dispatch for emergency. And once again, if vehicles are an issue, whether that is to be addressed. You want to know a statement determination of public agency or utility responsibility for street lights and sewer maintenance. Street lights may be the association's responsibility or could be the city's, depending on the area. You want to have that information insurance, so the association knows exactly what they're responsible for. You also want the appropriate public agencies, statements from them that have or have not released any bonds or permits. If there's still a permit out there for the pool house, if the bond is still out there, if that transition happens and that still happens, now the association is responsible for that matter. When I have all the statements that those are cleared out, and if they're not, then you know what to how to continue on with the developer before anything else gets worse. You also want any of and all certificate of occupancies and or other permits that are issued by the government. So if there are remaining units that have been completed and have certificate of occupancy, but they are not yet sold to non-developer homeowners, you want to have a copy of those just in case one real estate agent does not have it or there's any issues with that matter. And more things that you do want are, you want if the developer has created already accepted some applications with architectural design board for modification, for all those units, to know what they are, the rules and regulations that they have that set up for the bylaws, and what the rules and regulations are that may address some of the issues with the traffic matter. You want any financial documents, tax returns, for state and federal that have been filed. Once you have the books and records, you want to hire a CPA to review the reserves fund, but you also want to see any contracts that either the advisory board or the developer has signed, and original copies of any association employment contracts if the association has some. Richard, how about you for homeowners?
Well, one of the things that you absolutely need to get is usually, especially in subdivisions, it sometimes has it in the condo documents, but more frequently in subdivisions, is an executed recordable assignment of rights. The developer's powers and authority over architectural control, enforcement, and sometimes even construction. It's fact-based. You need to consult with an attorney about whether or not you want to try and obtain the remaining development rights that they may have. It's not like the condo association where there must be built, need not be built. But nonetheless, if you've got some land that's not being handled properly, you might be able to negotiate something out with the developer. As she's mentioned, again, these documents are all something you ask for. If you get them, that's great. If you can't get them, you will have to do some legwork on your own to see, to get the information from the various different entities, whether it's a vendor, a service provider, or the municipality. It's best not to, and people do ask this question, should we take control as soon as possible, or should we wait until all these problems are solved? There's basically two theories on that. I know some attorneys that say, nah, not until they take care of everything, or not, we don't want you to try and take control. And then the other theory is, no, get your hands on the books, the money, so that you're making the decisions for your community as soon as possible. I tend to lean towards that, at least my own personal preference. But again, it depends on the factual scenario and where you are in the development and what's transpired before you. You may not want to take on a huge headache, and that's understandable. But we're going to discuss that further when we get to another page further on in this presentation. Any questions so far? How are we doing, guys? All right, Jared. Are we on?
Melissa?
We are on page 10. As we mentioned already before, the laws governing a transitional control of the HOA, there aren't any really, other than anything that might be in the Michigan Nonprofit Corporation Act in terms of responsibilities, because the developers do have responsibilities in terms of while they are in control of the nonprofit corporation. They have a fiduciary responsibility to the corporation. In a recent case, it says also directly to the membership. There's a duty of good faith in dealing, and they need to address the issues of the common areas and address the municipality concerns. While they're in charge, they're the ones that have to make sure that everybody's happy one way or another. Again, I mentioned about builder concerns. They may not directly have the contract, but they may have the authority. They've got the financial wherewithal that, they're selling these lots to different builders. And you say, listen, if you want some more lots from me, you need to take care of some of these problems. And sometimes we've been able to work out issues or settlements with people with reference by getting the declarant for the developer to actually take control and take charge of the problem. All right. We've already mentioned all the different documents that Jazz has mentioned. You're going to want the same thing. You're also a nonprofit corporation. So if you get the tax returns, make sure that all the MARs are filed, make sure all the corporate articles have been, filed or amended as needed. The rest of it you're going to do once you have complete control on your own. Funding responsibilities are primarily accounting for what annual maintenance charges are being collected and how they're being spent. It's not correct, nor is it proper for them to collect maintenance charges and pay for obligations that's solely their obligations in the development of the community. You have to look at the fact that your maintenance charges are going to be going towards maintenance of common areas and or insurance of common areas and things of that nature. If you're paying particular improvements that aren't really common areas, then that's something that's going to be coming out. They should be coming out of their checkbook, and they need to account for that. I think previously on the other pages, we've mentioned all the different things you want to ask the developer. I did have in here, again, all the information you can get on amenities, any paperwork you can get that's going to create responsibilities or obligations for the association with reference to future administration of the affairs, any information about easements, access and utilities, any information about master controls, boxes, shutoffs, conservation easements, ponds, trees, landscaping. A lot of times these are in the declaration or in the bylaws. And it's important for you to get your hands on these documents. If it's not a public record, at least ask. You always want to ask what agreements are out there that we're going to be taking on that's not already recorded. because sometimes that happens. And you end up finding out after the fact when basically somebody's, at the board meeting, or you get a letter from the attorney from the municipality. So it's always important to try and ask for this information. Okay. All right, things you should do after you do get control. You want to perform an audit of the documents. Make sure that you do have all the documents. You do everything is proper with the state of Michigan. Everything, all the documents or all the easements and agreements with the municipalities or the state are available. They should be recorded. If they're not recorded when you engage an attorney, that's something you want to talk about when you're going to be amending your documents. It's probably a good idea to retain a certified public accountant, to have them go through the monies they've collected and how they've spent it, with reference to whether or not they owe the association, whether it's a condo or an HOA, any money, or have an obligation to pay for something. Hire a professional property management company, somebody that has experience in assisting in administering the affairs. The statute in the Condo Act, and Just can address this further, allows you, if the management company has been employed by the developer, that is subject to termination once you take over. It may be a circumstance where you want to hire a professional engineer for purposes of the amenities, especially when it has to deal with any water sources, retention ponds, detention ponds, culverts, landscaping or easement areas. Sometimes you're going to need an engineer to advise you in terms of what's there and what you need to do. For certain, get an attorney and not your brother-in-law's divorce attorney or whatever. Get somebody. There's a lot of good reputable firms out here. I tend to think ours is probably the best, but I might be a little bit prejudiced there. In any event, get association counsel, and then they're going to talk to you about amending the documents, and that is extremely important. And that we're going to talk about on the next page. So
what other additional actions should the board of directors take immediately following the turnover of control? The first one, once again, make sure that everything with the state is properly filed. If you have a articles of incorporation, but they have not filed the certificate of continuation for the last 3 years, or certificate of renewal for the last 3 years, your corporation could be dissolved. You need to make sure that everything is up to date. If there's any tax return issues, you have to handle that immediately. Well, going back to the funding, there is a law that the MCL 559-551 has a standard for the funding for reserved. Per the reserve study that the developer may have done may not be the proper one. You must have that old reserve study, and then you should do immediately another reserve study. Prices have gone up always, every day, and it's constantly changing. You have to make sure that you can maintain that reserve that is required by the law and within the assessments, which is 10%. Also want to have an independent CPA handle that, don't rely just on developer CPA. That's why it's important, as Richard said earlier, to hire a CPA, a certified public accountant, almost immediately, because you do want to get another reserve study to be done to ensure that your assessment fees at the monthly or annually or quarterly time is enough to maintain that within the reserve. Richard?
okay. If there's a current property management company, it's important for you to make arrangement to visit the offices and review all the documents that they have. What rules and regulations, or what decisions with reference to rules and regulations, what decisions with reference to architectural requests have been made. You need to know all this once you gain control of the association. Every community, and I don't care whether it's a condo or a subdivision, should have 5 different documents with reference to every single unit or lot that's in the community. 1, evidence of the ownership, whether it's a warranty deed or a land contract. 2, information regarding any mortgage that's on the property. 3, you want a duly executed designated voting representative form. They're called for in the Condo Act. Again, there's no act for associations, but there are corresponding statutory provisions in the Nonprofit Corporation Act that you basically shareholder or member has to basically say who's going to cast the ballot if the documents don't provide it. But you certainly want something to indicate who all owns the property, who's going to cast the vote for the property. And normally that's where I put the consent to receive electronic communications so that you can save money on postage and that all information can go to the designated person with reference for information regarding anything pertaining to the association. You also want to have information about the occupants, whether it's a lease or a rental agreement or what's called under the federal guidelines, non-owner occupants. Basically want to know who's on the property, who's going to be charged for the responsibility for violations of the documents, right? And the last thing that you really need to know, you can't wait until the house half burns down and sits there for 6 months. It's good to have a deck sheet on the insurance. Who has insurance on the property with reference to, so that you can take action in the event or unfortunate event of the circumstance of a casualty. So find out whether the management company has this information. If they don't, it's something that you're going to need to do and something that you're going to need to talk about with whomever you engage to be the property manager for your community. You need these documents to properly administer the affairs of the community. Okay, so now we're down to reviewing the governing documents. Well, you're going to probably want to amend the provisions as soon as possible that you have all the records and details with reference to who all the owners are. For one, you want to take out the things that are all skewed towards the developer. Well, the developer gets to do this, the declarant gets to do that. That's great, except for the fact now that he's out of there, or at least you may want to limit further that they have the absolute say in everything. You can negotiate this sometimes or something. Sometimes they don't want to be bothered with the minutia. All right, so it's easy enough to get an agreement or an accord with a developer or a declarant, but they're interested in making sure that the community is nice so they can finish out their sales and move on to their next project. Okay. The other thing you want to do is take out poison pills. You know, those are the kind of documents that say, unless it's for a collection or a violation of a bylaw, you can't file a lawsuit unless you get 80% of all the people and you get the history of the attorney, every lawsuit he's ever had, who is served or she, and the firstborn child and everything. Those kind of provisions totally inhibit the association from being able to operate. If you got a bad landscaper who's damaged a lot of your property, you want to be able to go after them and not have to get permission from 141 units or lot sites to be able to pursue it. You also have to be aware of, and I can't tell you how much this pops up. As a matter of fact, I've got a new community over on the west side of the state. What's called the evergreen provisions. When the declaration is recorded, they typically have the language, excuse me, this declaration is good for 30 years or 20 years, and then for 10 years, every anniversary date thereafter. Okay. And so if you're going to be doing any amending, you got to look at your time periods, because there is a published Court of Appeals case that basically says, well, you can do the amendments, but unless you strictly comply or have unanimous consent, it depends on the language of the documents, then whatever you amend doesn't take effect until the next start of the next 10 years. So you don't want to be stuck with provisions that you don't like and or are of no further value to the association. So it's very important to get competent counsel to take a look at your documents to give you an overview of what needs to be done on them. I do a lot of document amendments, and so do several other members of the firm here, because that's the things you need to do. These documents are written primarily and they're cranked out on a copy machine, change the first page, last page, this association by this ABC company that's here today and gone tomorrow. You want the documents to fit. If you've got a condo and it's got skylights or different things, the documents need to address those. And a lot of times the documents do not address what's been constructed. Well, there's a pond over here. Okay, whose pond is it? Is it ours, or do we share this with somebody? You don't know. You need to find out this information, and you get counsel to make sure that your documents, so that every time a question comes up, you've got an answer as to what it is, where it is, and whose responsibility it is. 75% of the time, the documents don't match what's there or don't tell you what to do what's there, or they have very vague provisions. Well, you're responsible for if, but there's no definition. If in default, well, what's the definition of default, right? There's also a lot of things coming up, solar, autonomous vehicles. Civil rights is huge. 45% of all complaints now are basically complaints about disabilities and failing to have a proper procedure for granting accommodations and modifications. That is huge. It's going to cost you $10,000 to $20,000 to $30,000 without even any kind of lawsuit. So you got to make sure that your documents, competent association counsel advises you as to, or makes recommendations by going through what's in your community with you, what's in your site plans, either your subdivision plan or your Exhibit B site plan, to make sure that everything in the printed text matches what the picture shows, and also to address things that's coming. And guaranteed, there's a lot of things coming that are in other states that's going to work its way up to the Rust Belt, so we say, in the Midwest here. I can't think, is there anything else that you can think off the top of your head, Justin, we might want to pass on to them?
I think you covered everything, to be honest. Anything else? Also for a condominium association to have the master deed and the site plan to determine what that claims what are limited common elements and general common elements. That will explain those issues and which ones that the association has responsibility for mailboxes, for driveways, for the street, for all these bushes around the one side of the sidewalk versus the other side of the sidewalk. These come up every day, whether it's responsibility of the association or the co-owner to do. And having the master deed and the site plan will determine that information and will allow the association to know what the responsibilities are and prevent any issues going forward.
I should mention too, when I talked about unrecorded documents, I think it's extremely important, because the biggest thing that you always hear is, well, they gave me a bunch of papers at closing, but I didn't read them, 131 pages or whatever it was. And then some of the documents aren't even recorded. So it's kind of like, make sure when your council redoes your documents, it all gets recorded. So you can say, look, it's public record. The people voted on it, they approved it. And this is what governs your community. These are the answers to your major questions. And a lot of times too, though, the associations don't look at the corporate articles. There's forms by the state of Michigan, and accountants or other firms will just sign off these 3 or 4 pages, and that's what you got. Because that's all you really need to do. And you need to have 3 board members for a nonprofit association. Problem happens to be is it doesn't address all the kinds of powers that the administrator of affairs, either of the condominium or a subdivision association, has to have authority to step in and do things, to abate nuisances, or like I said, you have a fire or something, and the house has been sitting there for 2 years with the insurance companies debating each other on who's supposed to take care of what. It's like there's nothing in the documents that gives the board any authority to say, hey, I'm going to take this to court and ask them to, get this fixed, or pass on the responsibilities. The documents frequently say in condos, anything that we have to do, we can charge the attorney's fees for, and you can't collect attorney's fees for any reason. Well, that's not quite fair. There's a violation of section 115 of it, for sure. And or they all say, well, in any proceedings, the association, whether it be a homeowners association or a condominium association, if there's a proceeding, they can collect the attorney's fees. Excuse me. Well, the court cases say that a proceeding means a court case. So if you send them a letter about dog poop, that's not a proceeding. So you're not supposed to be charging the cost for that attorney letter, or the management company who sends out enforcement letters. You can't charge that to them if there's nothing in the documents that authorize you to do that in the bylaws or in the corporate articles. Also, in the corporate articles, you want to take advantage of the provisions that changed the Nonprofit Corporation Act in 2015 with reference to how to vote, absentee voting, and very specific provisions. You want to make sure you have the authority. You can vote with or without meetings and how you need to follow those requirements, hold meetings electronically rather than in person or a combination. You want to make sure your documents authorize all these procedures and sets forth a procedure on how you can do it. So there's a lot to amending the governing documents that are extremely important once you get control. And again, this whole seminar is not just for like you're looking at taking over from the developer or the declarant. This is information that you need because you're going to be there for the next 20 or 30 years, or you and your successors are. That's going to be taking care of this community because that's your number one asset. It should, it should be aesthetically pleasing. It should be economically run. There shouldn't be a lot of waste, and it should be treated like a corporation. Even though it's nonprofit, it doesn't mean it doesn't have responsibilities under statute or the governing documents. So, do you have any questions there, Melissa?
We currently do not have any questions in the chat, but if you have questions, please drop them in the chat and I will ask our presenters as we are at that time. And we have Pugsley the Pug, who is waiting patiently for your questions and answers.
That looks like my pet after he's heard my problems with my therapist. Cute. I'd like to thank everybody for attending, and I think what you need to do too is spread the word. You missed out on a seminar, informational seminar that's not just about transitional control. It's about indicating items, documents, and procedures you need to do with reference to the future of your community. So I think we've covered a lot of details, a lot of things to ask for.
I'm just going to wait for a couple more seconds and see if there are any questions.
Richard, do you want to also talk about when amending the documents, responsibilities and privileges for successor developers for the condominium association? Whether they have to pay association dues, whether they're responsible for these undeveloped units that they have purchased. This comes up quite a lot for communities that are developed, but they still have units that can be developed.
Yeah, you've got to make sure that the documents address the circumstances whether it's must be built, need not be built in condominiums. Or I've got another community where they've got some vacant land that nobody's done anything with forever, and there's a chance for the association. So we're like looking for people that may have an interest in the property to let the association be able to find somebody to finish out the development. We do these negotiations all the time with under Section 67 of the Act with reference to abandoned projects and condominiums. But anyways, it should reflect, you should come up with a proper formula in terms of how the declarant needs to contribute for the lots, if necessary, rather than just sit on. Another thing that you need to talk about a lot is short-term rentals. And a lot of times if the economy is not, they're not making enough money to go ahead and build houses on it to sell, they'll build the houses and they'll rent them out either on a periodic basis. So that's why I said it's one of those things we mentioned earlier about getting all kinds of leases and the other agreements, or just sell them on land contracts. But assessments has to be part of the profit, part of the process, whether it's an annual maintenance charge or whether it's a monthly assessment for a condominium. These items need to be clarified in the documents, and a lot of times they're a little vague in terms of when the obligation starts and continues for developers or successor developers or declarants and successor developments, if there's such a phrase.
All right. Well, we don't have any questions. So once again, I would like to thank everyone for joining us on their lunch hour or during their afternoon. We really appreciate it. If you would like a copy of the presentation, I will stay on and you can drop your email to me privately in the chat, or you can email me at mfrancis@zdfattorneys.com. If you have questions for Mr. Wagner, you can reach him by phone at 586-465-1330, or by email at rwagner@zdfattorneys.com. If you have questions for Ms. Kalabat, you can reach her in our Plymouth office at 734-459-0062 or by email at jkalabat@zdfattorneys.com. We would encourage you to visit our website, www.zdfattorneys.com. We have lots of information on the website, and you can also follow us on Facebook, Instagram, Twitter, and go to our YouTube page. We will put up this video, and we have other presentations on there with a wealth of information. So again, education is key. If you ever have any questions, you know where to find us. Thank you and have a wonderful afternoon.